A lot of people assume that trusts are only for wealthy families, but that is one of the most common misconceptions that we come across. A trust can be one of the most practical tools for any family that wants more control over what happens to their assets, whether it's during their lifetime or after. I am Asthana at Southern Estate Lawyers. We help Alabama families create trusts and estate plans tailored to their specific situation. Let me walk you through what you need to know. Trusts come in several forms. The most common for Alabama families is the revocable living trust. You create it during your lifetime, and you remain in control of the assets inside the trust, and you can change or revoke it at any time. Other common types of trusts include irrevocable trusts, which work differently. Once they're created, they cannot be changed, but they could offer stronger asset protection and certain tax advantages that a revocable living trust doesn't provide. Another trust is a special needs trust, which protects benefits for a disabled loved one, and testamentary trusts, which were created through a will and take effect upon death. So, why do people choose a trust over a will? There are a few reasons. First is to avoid probate. Assets that are held in a trust do not go through the probate court. That means that your family receives those assets quickly, without much cost, without much delay, and without the process becoming a matter of public record. A second reason why people choose a trust over a will is incapacity protection. If you become incapacitated, your named successor trustee in the trust can step in your shoes immediately and manage your assets according to your directives. There is no court intervention required. The third reason is to have control over the distributions. A trust allows you to specify exactly how and when your assets are to be distributed to the beneficiaries, and that is done without any court supervision. For minor children or beneficiaries requiring guidance, that level of control, independent of court supervision and procedural barriers, matters. And the fourth is privacy. Unlike a will, a trust does not become a public document when you die. One question that I get often is, do I need a trust or is a will enough? And the honest answer is, it depends. For some people, the will alone works well, but a trust may make more sense if you own real property, multiple properties in a state or in multiple states. If you want to avoid the time and cost of probate, if you have a blended family or a complex beneficiary situation, if you want to provide for a beneficiary with special needs, or you're concerned about privacy after your death. If you opt the route of a trust, it is always accompanied by a will, often referred to as a pour over will. This will is like a safety net. It catches any asset that you did not place in the trust. There is one vital step that many people miss after creating a trust. That is funding it. A trust only controls assets that are actually transferred into it. That means changing deeds, retitling accounts, and updating beneficiary designations where applicable. A trust that exists on paper but has not been funded is only that, a piece of paper. It does not help protect the management of those assets if you become incapacitated. At Southern Estate Lawyers, we walk clients through the funding process because drafting the document is only half the job. A few things that people often get wrong about trusts. First, that the trusts are only for the wealthy. If you own a home, have children, and want to avoid probate, trust may be a very good option for you. Second, a lot of people think that a revocable living trust protects them from creditors. That's not right. Think of a revocable living trust as a flow through to you. Because you retain control of those assets in the trust, those assets are still reachable by creditors. And third, many people think, oh, trust is very complicated to set up. But with the right legal team guiding you, it really is a straightforward process. In Alabama, trusts are governed by the Alabama Uniform Trust Code. It sets the rules for how trusts are created, modified, and administered. A trust in Alabama must have a clear purpose, a named trustee, and at least one beneficiary. The trustee has a legal duty to manage the trust assets pursuant to the directions in the trust. Alabama also allows for the amendment and termination of trusts in certain circumstances. Getting guidance from a competent estate planning attorney right from the start prevents disputes and complications later down the road. As Southern estate lawyers, we start every trust conversation with a free consultation. We look at your assets, your family situation, and your goals. And from there, we recommend the right type of estate plan and trust, or if a will alone is the right option for you. We draft the trust document with Alabama's specific requirements in mind, and we walk you through the funding process so the trust is valid and does what it's meant to do. We have offices in Mobile, Foley, and Birmingham, and we offer in person, phone, and video consultations. If you are wondering whether a trust makes sense for your family, the best first step is a free conversation with us. So give us a call, and we look forward to working for you.